The grand jury system has been in the news a lot lately. There have been some very high profile cases. Of course, here in Texas, you've got the indictment of a sitting governor, Rick Perry. You also have the recent indictment of the athlete Adrian Peterson. And also a case that's received a lot of publicity in the Houston Chronicle where somebody received the death penalty, and then it turns out that a witness that would have supported the alibi of that defendant who received the death penalty was intimidated into changing her testimony before the grand jury and to testify in a way consistent with the prosecution's theory and ultimately lead to somebody getting the death penalty that it appears was innocent of the crime that they were accused of. Now, exactly what is a grand jury? Well, it's been around a long time. The grand jury actually came into existence at the time of the Magna Carta. And basically it's a group of people that are deciding whether or not there's probable cause somebody committed a crime. They're not deciding guilt or innocence. They're not deciding whether there's proof beyond a reasonable doubt. They're not even deciding whether there's proof by a preponderance of the evidence. All they're deciding is that there is at least enough evidence that somebody has committed a crime that there ought to be a trial to decide whether or not the state or the government has met their burden of proving guilt beyond a reasonable doubt. Now, the grand jury system came to this country along with the colonists that came over from England. It was in England and they brought that system with them. And in theory, it's supposed to operate as both a sword and a shield. A sword in the sense that it can cause somebody to be indicted for a felony, and a shield in the sense that, at least in theory, it's a body of unbiased citizens that are going to determine whether or not there's enough evidence to indict somebody for a felony, and not simply allow the king or the federal government to just charge somebody. So in that way, at least in theory, it's supposed to be a shield from an overbearing government. Now, in truth and fact, as the saying goes, a grand jury will indict a ham sandwich. And what I mean by that is it's a very one-sided affair. And there are some recent cases that illustrate that probably better than anything. I mean, it's hard to imagine one more illustrative of that than the indictment of Rick Perry. And without playing politics and without deciding whether Rick Perry did something right or did something wrong, it's pretty amazing that a sitting governor was indicted for 2 felonies based on what was at least arguably following duties that were conferred to him under the law. And I will get into that in a little more detail. But in any event, a grand jury usually doesn't operate much as a shield. There are several reasons for this. In Texas, unlike the federal government, a grand jury is generally selected by commissioners that are appointed by the judge. And they will find people to sit on the grand jury. And the people they find are often associated with the clerk's office, they're associated with law enforcement, they're people that want to sit on a grand jury, and they're people that are heavily biased toward the state. As a matter of fact, the Texas system has been called the, quote, pick-a-pal, close quote, system. You should contrast this with the federal government, where people are just selected at random from voter lists and different registration lists that are totally unbiased, that are neutral as regards to race, that are neutral as regard to whether they are pro or con against law enforcement. And I submit to you that the state of Texas ought to carefully consider this, because there have been a lot of high-profile cases in which the judgment of the grand jurors have been called into question, and whether or not the grand jury has been biased or whether it's politically motivated or the like. Now, what is a grand jury? Well, in Texas, it's 12 people, and they meet in a room behind a closed door. A prosecutor is in that room, a court reporter is in that room, and a witness is brought in one at a time, and they hear testimony. A defense attorney is not allowed in there. Nobody is allowed in there, and except for a court reporter and sometimes an agent to assist the prosecutor. And it's a secret proceeding. You're not supposed to reveal what occurred behind those doors. And importantly, the prosecutor has no duty in front of a grand jury to present exculpatory evidence. That is, if there's evidence that would show that a defendant may not be guilty, and even if that evidence is brought to the attention of the prosecutor has no legal duty to bring that evidence before the grand jury. Now, what prosecutors often use a grand jury for is a tool to get them off the hook. For example, if they really don't think somebody should be indicted, but they don't want to take the heat in a publicized case for not going after somebody, they can simply present it to the grand jury and say the grand jury decided to no-bill the case. Well, what generally happens is the prosecutor controls to a great degree what the grand jury does. Although the prosecutor doesn't get a vote, the prosecutor can steer the evidence before the grand jury, can make comments to the grand jury as to whether or not the prosecutor thinks an indictment should be returned, or alternatively to provide theories to the grand jury why it doesn't look like an indictment should be returned in a particular case. Now, a federal grand jury is made up of 16 to 23 people, and it takes 16 at a time to be in the room to have what's called a quorum. And if any less than 16 are in the room, business cannot be conducted for even a second. And then it takes a majority of the grand jurors that are in the room to return a true bill. Now, some of the cases that have received a lot of publicity, as I said before, one of them, Governor Rick Perry. And probably a lot of you are familiar with the facts of that case, but the district attorney in Travis County got arrested for driving drunk. And she was videoed by the police drunk. And she really makes, quite frankly, quite a fool of herself. She makes a drunken fool of herself. At the same time, she would not resign her office. She was also in charge of a public integrity unit that, at least according to the state's theory, was looking into or investigating whether some organization was showing favoritism to backers of Rick Perry. And so, at least according to the prosecution theory, Rick Perry was trying to get her to not be investigating his backers and basically threatened to take away the funding of the public integrity unit if she didn't resign. And she refused to resign. He then told her he took away, vetoed, and the money was gone. So there was no money for this particular unit. And an independent prosecutor was appointed to look into this, presented it to the grand jury, and the grand jury found that Rick Perry, by doing that, had committed 2 felonies. Of course, there was no evidence that was presented of any of the defenses, and it really is a pretty startling development to indict a sitting governor over what certainly appears to be, at first blush, a very flimsy criminal case. One of the other cases that's got a lot of publicity in the Houston Chronicle deals with a death row inmate. And he had an alibi defense. He said that he was at his girlfriend's and then she left to go to work, and then he called her from her place. And she was called before the grand jury, and she basically corroborated his story. But the foreman of the grand jury happened to be, and there's some debate over whether he was a present police officer or a former police officer, but in any event, definitely law enforcement biased. And she was basically threatened that if she covered for him and didn't change her story, that she would be indicted for perjury and her children would be taken away from her. So after being threatened with being indicted for perjury and having her kids taken away from her, she changed her story and denied this alibi. Well, lo and behold, 7 years later, in the garage of an investigator, appears evidence of this telephone call that, in truth and fact, he did place a telephone call from her place to her at work, corroborating her initial story. And as it presently stands, he's on death row. So that's another problem with our grand jury system, is that you can have people that are biased toward law enforcement. There are really no rules of what goes on in there, and that witnesses can be intimidated to lie in a way that favors the prosecution. And finally, one of the latest that was just in the paper the other day was Adrian Peterson. Of course, I'm sure many of you have seen where he has been accused of committing an assault on his child by what his attorney referred to as giving him a whooping with a switch. And of course, there, sometimes is a fine line between, what's a spanking and what's discipline of a child, and what is actually child abuse. And in this case, apparently, some of these photographs have been leaked to the media, and apparently show some pretty severe bruising, arguably supporting the prosecution's theory that this went beyond a mere spanking and was really child abuse. But the part that's getting a lot of publicity right now is that the foreperson of the grand jury is a woman that works with the clerk's office and is, close with the district attorney and works with those folks all the time. Now, does that mean she's biased? Not necessarily. But really, the system should be beyond reproach. And rather than the pick-a-pal system, it ought to be more like the federal system where people are selected at random and don't give the appearance of bias. In conclusion, in theory, the grand jury is something to protect the innocent citizen from the power of the government. And practicality, I question whether it is, and hold to the adage that a grand jury will indict a ham sandwich. If you find that you are under investigation, you should never appear before a grand jury. As a matter of fact, you need immediate legal representation by an attorney who's skilled in grand jury practice. There are ways of getting your story before a grand jury without you appearing there, without your lawyer, and being cross-examined under oath, with a court reporter taking down every word, and a prosecutor whose goal is not to see that you are no-billed, but to gather evidence to try to convict you. Now, the way that attorneys are able to, and many times very successfully, get your story before a grand jury is to put together what's called a grand jury packet. And it's basically to present your complete defense with any type of exhibits, any type of testimony, any type of argument, any type of legal argument, and provide copies to the prosecutor to distribute amongst the grand juries. And although the prosecutor is not obligated by law to present that to the grand jury, most of them will do so. And the reason that they will do so is, quite frankly, prosecutors like to win their cases. And if they are going to end up losing the case because of the defense you're putting forth, they'd rather find out earlier than later. And if a grand jury isn't going to find probable cause to indict somebody after hearing the defense, then a trial jury certainly is not going to find guilt beyond a reasonable doubt.